It is not in dispute that the President bears an elevated status by virtue of his office. The President has additional roles and obligations in comparison to the ordinary Kenyan. In addition, Article 132 of the Constitution mandates the President to safeguard the sovereignty of the public, promote and enhance unity of the nation, promote and respect the diversity of the people and communities of Kenya, and ensure the protection of human rights and fundamental freedoms and the rule of law. Article 132(1)(c) of the Constitution stipulates one of the many mandatory functions of the President. The President must, once every year, report in an address to the nation on all measures taken and progress achieved in the realization of the national values referred to in Article 10. In my considered view, the President is not limited as to those measures he can take to undertake he's not limited as to the measures he can undertake in the exercise of his functions under Article 132. The said measures could constitute a policy, statutory, or constitutional frame. Clearly, in promoting and enhancing national unity, the President can promote constitutional amendments through popular initiative. This would qualify as a measure taken under Article 132 on which progress achieved can be reported. It is directly within the four corners of the Constitution of Kenya. I am convinced that when the President takes measures in the exercise of his functions, including a proposal for the amendment of the Constitution, he is bound by the oath prescribed by the Constitution and which he swears when he takes office to act in the best interests of Kenyans and not to undermine democracy. One need not worry about the President overstepping because the parameters in the Constitution are sufficient to rein him in. How can I claim this so boldly? This is informed by our constitutional history. When one looks at the history of constitution making in this country, it is clear that one of the intentions of the drafters of the Constitution was to discard parliamentary monopoly over the constitutional amendment process and to make it more inclusive. Kenya's journey to democratic constitution was arduous, taking into account that most of the amendments made in the taking into account most of the constitutional amendments made in the first President Kenyatta's era. In the first President Kenyatta's 15-year reign, he oversaw 16 amendments. President Moi, in his 24-year presidency, oversaw 14 constitutional amendments. Both presidents were members of parliament and used parliament to amend the constitution in a manner that excluded participatory democracy. The people were not involved in any way. By 1992, and because of this, all key institutions, the judiciary, parliament, public services, security forces, and the provincial administration were instruments of authoritarian control. Concentration of power in the President was one of the factors that prompted demands for a new constitution, and the 2010 constitution aimed to curb dictatorship by parliament in the amendment process. Kenyans wanted to have a head of state who would not whimsically amend the constitution. They wanted to limit the powers of the constitutional amendment by the head of state, but not to take it away altogether. In other words, the intention was to make it difficult, but not impossible, for a president to make a constitutional amendment. This is the mischief that the framers of the Constitution sought to address. In my considered view, therefore, there is no historical evidence that the drafters of the Constitution intended that the President be excluded from the popular initiative amendment route, or that it be limited to a specific class of people to the exclusion of others. If anything, the resultant very expansive Chapter 4 on the Bill of Rights in the Constitution of Kenya 2010 proves otherwise. The President enjoys all constitutional rights and freedoms like any other Kenyan. He is first and foremost a Kenyan citizen by birth. A president does not lose his or her political rights under Article 38. He or she does not cease to be a registered voter by virtue of ascendancy to presidency. There is no law pursuant to Article 24 of the Constitution, which is the limitation clause, that limits the president from enjoying political rights under Article 38, especially that of campaigning for a political cause, which in my view includes constitutional amendments. In addition, trusting citizens with public office does not in any way muzzle them or take away their rights as provided in the Bill of Rights. Article 27(1) of the Constitution provides that every person is equal before the law and has the right to equal protection and equal benefit of the law. Additionally, equality includes the full and equal enjoyment of all rights and fundamental freedoms, and the President, like all Kenyans, is obligated to respect, uphold, and safeguard the Constitution. If any Kenyan has the right to initiate a popular amendment to the Constitution, while respecting, upholding, and defending the Constitution, so too does the President in his official or personal capacity. It would be restrictive, unjust, unprogressive, and unconstitutional to limit that right. At this juncture, I find it prudent to comment on the submissions that the President is excluded from promoting changes to the Constitution by popular initiative because he can do so through Parliament. According to Article 256 of the Constitution can only be amended through a parliamentary initiative. Under Article 256 of the Constitution is silent as to who can introduce a bill into either of the Houses of Parliament. However, the composition of Parliament is clear, and the membership of the National Assembly is provided for under Article 97(1) and that of Senate under Article 98(1). The President is excluded as a member of Parliament. In other words, the President is not a member of Parliament, and by parity of reason, he cannot introduce a constitutional amendment through a parliamentary initiative. Apart from making the finding that the President cannot initiate constitutional changes, the Superior Courts also found that state organs similarly cannot initiate such changes. However, it is important to note that all state organs and state officers form part of the national executive, county governments, the legislature, the judiciary, independent commissions, and independent offices. Accordingly, then, all holders of such offices under Article 1 also exercise delegated power from the people and must perform their functions in accordance with the Constitution. If those functions require measures or policy actions that would require constitutional changes, then they must be able to use their delegated authority to exercise those functions. To suggest otherwise would result in an absurdity. For example, let us assume that Chief Justice, as the chair of the Judicial Service Commission, wishes to make proposals on judicial reforms. And she puts together a draft bill and presents it to the IEBC as a promoter. If we are to follow the findings of the Superior Courts, the Chief Justice would find herself barred from proceeding. However, if her Chief of Staff or the Deputy Chief Registrar were to take the same document, it would be acceptable. Similarly, if the Speaker, as the Chair of the Parliamentary Service Commission, wished to make some proposals, constitutional proposals around parliamentary reform, the judgment of the Superior Court would prevent him from taking such amendments himself, although the clerk of the National Assembly and the head of the legal department in Parliament can do so. The result is leadership without authority. In a democratic government, it is an untenable absurdity. In conclusion, I'd like to say on this point, the popular initiative amendment is not a preserve of specific persons. Any Kenyan can originate and promote the popular initiative amendment, and the people, as defined in the Constitution, also mean their representatives exercising donated sovereignty. As such, it remains an inclusive process and not a process that excludes and that empowers every person to propose constitutional amendments. Having found that the President and the state organs can promote a popular initiative, who then was the real promoter in the impugned bill in the dispute before us?